Morning, Jean. Would you like to introduce yourself to everyone? We're just going to do this podcast course. We've not actually met before, have we? And I'm really interested to find out what you do and hear about some of your case studies and just have a chat really about what you feel and think the system's like at the moment, if you've seen any improvement at all, or you think it's got worse. What's your view on all of that? Because I know you're a
Okay, lovely.
McKenzie
Thank
friend,
you.
aren't you? You're a McKenzie friend, aren't you,
Yes.
Jean?
Yeah, so I am a trained professional McKenzie friend, but also my background is in financial planning, and I've also done, coaching and divorce coaching in particular. So I kind of blend all that together when helping my clients. But essentially, I focus on helping people through the court process, but not exclusively. So, as part of my ability to coach people, when they're in the early stages of realizing that their case has to go to court, which obviously is a big step for a lot of people who wants to go to court, let alone divorce, it's helping them understand what that landscape looks like and breaking it down for them, and helping them stop that loop of maybe it'll work out, maybe I'll have another conversation, maybe we'll be able to sort it out, etc. And then get them court ready, which involves getting all the paperwork ready, attending court with them to support them, take notes, and often where there is domestic violence or abuse, to be able to be that human wall, if you like, even though there's special measures in court, but to be that human wall so that no barristers or anybody else might sort of intimidate the clients.
How many cases would you say are the majority domestic abuse, or
Yeah, I think, sometimes the people themselves don't even realise
yeah,
that it is domestic abuse,
yeah,
because it doesn't have, as we well know, it doesn't have to be the physical punch in the face or the strangulation. It can be, and I'm finding it more and more, the control, the manipulation, emotionally, psychologically, and also using the children as weapons if that person's not getting their own way.
yeah? What do you what's your view on the family courts? I think most people know what my opinion is on it, but this is your time to get your views out there on
Well, obviously, as
what
a
you
Mackenzie
think.
friend, I can't speak in court, so I can't directly liaise or challenge powers that be, whether they're magistrates or judges. But often you can read the room, and I think I was saying to you earlier in our sort of pre-session conversation, really, is that in cases of domestic violence, there's very often multiple court cases going on at once. So that could be child arrangements, financials, um, you know, uh, non-moles, etc. And what I'm finding in particular with a few cases at the moment is that the courts aren't taking into account what's going on in the different cases, that they specifically hear the financial application or specifically hear the child arrangements. But they're not joining up the dots in terms, or have the ability to oversee the case. Now, I know that's not their role necessarily, in fairness, but in cases of domestic abuse, that's what the whole thing's about. It's about post-separation abuse, taking people through court, intimidating them, taking them to final hearings, economically abusing them because they know they haven't got the funds to defend themselves or attend court, or if they're looking after children, even the time to get to court. So then they fall in default of court for not turning up, and everything becomes very much in less in their favour, and this
Yeah,
again is just ongoing abuse and control.
yeah,
So I'm finding a lot of that now. More recently, the courts have included, especially when it go to a final hearing, to avoid cross-examination of domestic abuse individuals, the facility of a qualified legal representative, which can be appointed by the court. However, there's two issues that I'm finding currently with that, is that, one, that there's not many of them, um, and Two, if you can get one, it very often defers the hearing date because of the scarcity of them.
Yeah.
So whilst they may feel that they're getting some support, actually the abuse is going on much, much longer because the hearings are being deferred to wait to appoint a qualified legal person.
Yeah.
And notwithstanding the fact that even that qualified legal person is there on behalf of the court, really, they're not like an independent barrister or a lawyer, but they can help, obviously, and it's better than nothing.
Yeah. I think we both agree that, nothing's joined up, is it? Even when they've got ongoing criminal investigations, I don't think that if there is a non-molestation order in place, I don't think that's taken into account either. My view on it is that non-molestation orders aren't really worth paper they're written on.
In fact, you just echoed some words of one of my clients, because she's applied for non-mol and then it was converted to undertakings. She's breached the undertakings.
What is an undertaking? Oh my God! So it's a promise to the judge. Yeah. Yeah.
But what's happening is he's using this loophole, if you like, and one client in particular is being barraged with third party intimidation, even though that's in the order itself. Proving that audit trail of who's doing it and why is very, very difficult. But this is a strategic, continuous...
even with evidence of text messages, emails, or whatever, this still doesn't take it into account. And I think that, we've just mentioned undertakings. Just to explain to everybody what an undertaking is. It's basically a promise to the judge. So, yes, sir, I do promise that I will not breach this order. What sort of deterrent is there to that? None. Absolutely none, is there? It's an absolute waste of time.
It is. Because there's no penalty. Obviously, an order is arrestable, but even that's difficult. Because if, again, third party or anonymous calls are being made to police, for example, on a welfare check, third party intimidation. I have a client that was, visited at 6 o'clock on a Friday night, wanted to come into our home. She wasn't aware of any particular reason why that was happening, but it was initiated by the partner, just trying to again put footprints down to support his case, even though he hadn't seen the daughter, who is a reasonable age of 14, for over 2 years, and at the same time trying to evict the mother and the daughter from the house. Yeah. He couldn't make it up.
No, I think you've got to live it to believe it, to be fair. How many years have you been a McKenzie friend for?
Not that long, to be honest. So I've been a McKenzie friend about 3 years now, and I just dive straight in. Like the more exposure you get to the court process in particular, the more you learn. And obviously what was has been the greatest insight to me is the exchanges from solicitors to clients. So I get clients that come to me, A, because maybe they haven't got enough money to have a solicitor, or and B, because they've run out of money because they've been using the solicitor and just haven't got anywhere. So when you start to see how the legal process works and how, people are drained of whatever financials they might have to support themselves without any proper progress, because even solicitors can't influence the judge, it's based on law at the end of the day, and it is antiquated. And I think that's half the problem, is that the law is very antiquated, and it's a very closed boy club type thing, supporting each other. And when they see a litigant in person, to be honest, I've seen a little bit more respect for little litigants in person coming through. Maybe it's those that have got a McKenzie friend, so that they're not going in unprepared and breaking down and crying. So there is some progress being made within the hearing. But it's still very far off the mark. And I have sat there and my jaw has dropped sometimes when, the magistrates or the legal representatives or even the judges and the way they've spoken to the individuals.
Yeah.
And
It's disgrace. I've heard judges speak to victims, and it's absolutely disgraceful. What's some of the things I've heard? Absolutely disgraceful. And
I think in their minds, particularly, so I think there's two types of if I were to categorize it, there's two kind of people going into court or going through the court process. Or one is one that's just been completely broken down, obviously, really struggling to articulate thoughts, emotionally sort of, fragile. And another one who's think, right, it's the day's come, this has got to happen, I need to get through this and over it and out. Okay. So those kind of people tend to do a little bit better in court. But when I think judges see people that are particularly fragile, they write them off. They haven't got the time. They, even though perhaps the domestic abuse is more evident because they're so broken down and emotional and fragile, they just tend to go, can't deal with that.
Yeah. What's your opinion about? Because I think the courts need opening up. I don't understand why we've got them in secrecy. And I also don't know why we can't have remote hearings for victims. Because even with special measures, it's still not good enough. It's still...
Yeah, I've got the remote hearings are offered occasionally. My personal opinion of those is that they don't work as effectively as in person. I know in person is more intimidating, but at least you do get that human contact and exposure, which I think is a bit harder from a remote basis, especially if you aren't legally represented, because you're still having to answer questions and prep on your own, albeit not physically there sat beside the person or in the vicinity of the person in the courtroom.
So for instance, I've sat in a remote hearing and supported somebody, and I've been sat beside her holding her hand, so she hasn't had that traumatic experience of actually having to go to court knowing that the perpetrator's in that building. Because even with special measures, I still think it's too traumatic. And, we were okay in COVID to have them remote, and they still managed to work that way. So I just think that it would save so much trauma if it was done remotely with somebody by the side supporting them, so that the court knew that that person's there. Do you know what I mean? You can sort of... It's still obviously traumatic seeing your perpetrator on a screen, but I still think that it's less traumatic if you're not in that building.
Yeah, it's one step removed. I mean, I suppose in an ideal world, it would be lovely to have little units around the country where these people can come to for their hearings on a remote basis into court, so that they've got the same sort of, infrastructure and support. And, a lot of the clients that I have worked with as well do struggle with IT, or they're dyslexic or ADHD. So sometimes dealing with getting online can equally be as challenging on top of everything else.
Yeah.
So that's a factor too.
Yeah, but if they had got that support there, then I think that's another way, or it being less traumatic as well.
Absolutely. I mean, and that's why I take pride in what I do. Sometimes I feel like I've got, carry an awful lot of the emotional, I was going to say baggage isn't the right word, but the emotional support for a person through court. And I think McKenzie Friends throughout the country are helping to change the experience in court for people, in the sense that there is someone physically there beside the individuals and to support them, when they're out, particularly. So with financials, for example, you have a hearing which is very numeric and factual, albeit there can be a lot of domestic abuse factors coming into there, like taking a person to court for financial so that they don't have to pay child maintenance, or they're trying to suggest that they've got the equivalent housing needs, but they've got no interest in the children at all. But when you go through an FDR, which is like a second hearing where a judge kind of gives an indication of what that settlement looks like, you're often dismissed from the court, but you have to stay in the court building sometimes for the rest of the day. And I've had people literally, almost get down on their hands and knees and say, thank you, I'm so pleased you were here. Because what happens is they use the barristers to then find the individual, and then start intimidating them. I had one case where a barrister, and honestly I was hyperventilating myself, and I'm quite a strong person, where she was suggesting that she would get a certain financial settlement if she allowed the father to see the child, who had also incidentally said that he wasn't even the father of the child. But she was vehemently arguing and challenging this young woman who, the baby was only about 4 months old. So the behaviour of some of these professionals in court, I think, could be changed.
Yes.
Because they are supposed to be neutral, they are supposed to be fair, but I think some of them get on their own soapbox and they want to be seen for the professionals that they are. But intimidating clients in court should not ever be one of those.
I've seen it where some of them are like best friends. Like some at Solicitors, they're organising where they're going for lunch and things like that,
Back scratching.
And I just think, oh my God, do they sit there, having a bet who's going to win? Because it's like that sort of thing, innit? Pat on back and, and I just think, do they even have any idea that these are people's lives that they've got in their hands?
Absolutely.
These decisions that they make, if they're not right, then that's devastating for that family.
I remember quite recently going to a private FDR, and it was, in the chambers in London, and no one really wants to do that. But we had the judge, we had both barristers, and we had the solicitor, we had a PA, we had this private room with this, little private bar with soft drinks and snacks, and then sandwiches arrived, and the barristers were, in and out of their rooms chatting with each other, and we went through this FDR, which I personally don't think should have even happened because it wasn't FDR ready for financials. And ironically, they already had a final date in the diary for a final hearing before they'd even done the FDR. So, yeah, it's shocking.
It's like a little trip out, innit, for a picnic? Bit of a picnic going on and a bit of socialising while they're there. And
then even dietary requirements.
Yeah. Bloody hell, I could do a job like that. I just think for us, because we're on front line and we're seeing this a lot, and it's not getting any better, is it? I don't think it is anyway. I think it's getting worse.
I think a lot of this came about with the demise of legal aid. Even if you do qualify for legal aid now, finding a legal aid solicitor that's going to do a good job is like a needle in a haystack. And I think that's the biggest issue in supporting these people, because we don't necessarily wake up and go, oh, I'm going to go to court. There is a lot of sort of support along the way, and it can start with a non-mol order. I've got clients that should have non-mol orders that won't do it because they're scared of, even though you can do it without notice, they're still scared of the potential fallout of that. I've got a client at the moment that is living in a very, very, very toxic situation, and she's just looping, I won't take action and go to court because of the children and the way that the partner is weaponizing the children against her, and that's all she's got left. So she is stopping herself from separating from the situation because of other factors. So yeah, you've got this barrier to actually getting into court, which ultimately is the only way of getting a solution, whether it is for child arrangements or financials. I myself work. I have a lot of empathy and I have a lot of emotional support, but my methodology is kind of like very practical and pragmatic, because in my book you've just got to get through this by hook or by crook, because you've got to get the legal divorce done, you've got to get the financial separation done, you've got to, if and where necessary, the children and all the periphery issues around that. You've got to get them done before you can even start to move on. And
Yeah.
people can move on, they may not realize it, but I used to be a business startup coach, for example, as well, and I would say to some people who had been made redundant, lost their self-esteem, etc., even if you're stuffing teddy bears on your kitchen table and earning money to pay your bills, that's great. So these people do have skills, they've lost it, they've forgotten who they are. So they need a lot of, they will need a lot of support coming out of this as well. And there's nothing really there. Who can afford, a whole coaching scheme, so it is very, which is why, resolute, organisations such as yourselves are just, gold really in this society now.
Yeah. I mean,
There's not enough.
I know this is it. There's no funding. There's no funding available, and it's as simple as that. We're kind of struggling like mad, as a lot of women's services are, because they just don't fund us. There is funding there, but for bigger charities. And we're only like we're just a small fish in a really big pond at minute. I don't think that's going to be the case for much longer, I'm hoping, because we are all lived experience and we are all volunteers, and the thing is, the only thing that drives us is that passion, because we know what these women feel like. We know what they feel like when they're going through this. Some of the cases that I've dealt with are just horrific, absolutely horrific. And it's soul destroying when, you've got judges making these decisions when they're based on, a lot of time, false reports. Social workers get it wrong. They can get it massively wrong. And then that decision destroys that family. And I think that judges don't hold social workers accountable. I don't know if you see that.
I think that's the irony of it, isn't it? Because very often the people that are or convincing the court, they're financially abusing the victim, the perpetrators, because they're sat there with barristers and the victim sat there with nobody. I've lost my train of thought now. Because of their narcissistic tendencies to be charming, be influential, all the traits that they've used to demean the victim, they're using in court, and then the court is then actually abusing the individual in court again, because they're believing what is actually being said through, as you say, the false reports. As I say, I've had one go to Section 37 report recently, because he's accused the mother of having 60 animals in her house. I mean, how, it's just not even believable. Who could possibly have 60 animals in their house? And this is in the CAFCASS report. So they've gone from Section 7 to Section 37, and this girl has never been late for school. rides horses, is happy, and yet now they're having to go through that trauma when the mother, is already being, you know, what's the word, consistently abused, and is in numerous court hearings and waiting for spinal surgery herself, but not booking it in because she's afraid that she's going to lose her daughter if she doesn't attend the hearings.
I mean, is that not just common sense stuff? Because that to me is just like, you surely to God you can see straight through that, what's happening. Or is that just because I know what, I can pick it out, like, it's so transparent, it's unbelievable. But is that not common sense?
Well, it is to me, but I think, everybody's trying to cover their backs, liability and, insurance and, and also there seems to be a wave of change slightly where historically, I think through court, it's being felt like the dads have been shortchanged and that their rights need to be heard and seen and respected, so that the balance of, obviously the child has the right to see both parents is being more fully considered.
Yeah.
Which sometimes,
that can be at any cost, and I don't agree with that. The presumption of child contact needs to be looked at, because ultimately, if you've got a person that has been, convicted of rape or any sort of abusive behaviour that they've had convictions for, then surely that should automatically raise some serious doubt as to that person having any contact whatsoever with that child. Because I've seen scenarios where, the presumption of child contact causes way, 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 way more damage than, contact going ahead. It causes so much psychological damage to a child. And I think it is emotional abuse that's created through the system, and that's wrong. If you've got a child saying, I do not want to see my mum or dad, it needs to be, start listening to the child. That child, more often than not, has also been a victim. And supposedly children are victims within their own rights. But that's not the case from what I see at all.
And I think there's no consistency about, sort of the child's voice being heard. So I've got an experience of a case where a 6-year-old, so the dad's breached the contact order, the 6-year-old's with dad, won't let him see mum, and has told CAFCASS that the child at 6 has said he doesn't want to see his mum. And CAFCASS have said, we can't make him see you, okay? Versus a 14-year-old that categorically says, I don't want to see my dad, and they're doing a Section 37. So
but I've had a case where, a 14-year-old boy has witnessed domestic abuse, and he has, said he does not want contact with his father. And so the assessments start, is he competent? And psychological assessments and things like that. And I don't agree with it. He's 14 years old, and choose what order is put in place. How can they force a 14-year-old lad to go and have contact with somebody? It's not possible. They can't do it.
Bring him, can you?
Exactly. So what is the purpose?
I know there is make them available, as in not making them available, but
No.
actually you can't physically make a child of that age see it,
But yet they're still doing all these assessments.
Yeah.
Where's the sense in any of that? And dragging this case on for nearly 2 years. You know, at the end of the day, if that judge court orders it that, yes, he goes and sees his dad once a week, what are they going to do? Physically drag him there? He's 14. They can't. Most 14-year-olds you know, they're off out with their friends and stuff. So what is the purpose of dragging the mother, who's also a victim, through this court process? And, you know, at times she's got severe PTSD, and also at times she's actually thought she's going to lose residency. And I'm like, but how can they force him? They cannot force him. They can court order it, but they can't make him, because that's breaching his human rights.
Yeah. No, I agree. I mean, I think again, in an ideal world, I know there is a certain procedure once domestic abuse is recognised in the court, you know, fact finding and you know, these reports. But I don't think it's sort of kind of siloed or segregated enough to be specific to the domestic abuse. It's almost, okay, it's non-standard.
But you've got solicitors telling victims not even to disclose it or don't disclose it.
Yeah.
So it's like, what are you meant to do in that scenario if you are a victim and a solicitor's saying to you, better off not mentioning that?
Mm.
Have you seen that?
Well, yeah, I've been privy to that, because sometimes, ironically, that, you know, the men can be victims.
Yeah,
and
absolutely.
So if they're making the applications, what they're trying to do is do the soft touch, i.e. put in the C100 for the child arrangement application, but not do a C1A, even though a C1A could be done, just to try and not mushroom the court proceedings. So, but even at that, it doesn't seem to necessarily work. I mean, the amount of spurious allegations that I've seen from perpetrators against individuals, just to crush them, just to intimidate them, or and try to avoid them. So it could be approaching like a financial hearing, for example, and they will then they'll just pull something out of the hat, knowing that the particularly paternal and maternal, but you know, using the children as the emotional gauge in order to try and influence other hearings, and that's the worst case. I mean, I try and I don't persuade, but, you know, obviously when I'm talking through options with individuals, I try and, you know, if you can avoid court for children, avoid it.
Yeah.
You know, that's.
But I'm sure you'll agree with me that, you know, it's virtually impossible to mediate with a perpetrator because it uses that control, isn't it? And there's no way that you can move forward. When
the courts have now introduced a new form. So if you do your MIAM or you do a mediation and it fails, so out of court alternative mediations, there's a new form now which you've actually got to complete before court, to explain why out of court, you know, alternative options has failed. So maybe that would potentially change the curve, because at least then the court has an initial understanding of why things aren't settling out of court, and potentially understand if those forms are filled in well, have an initial heads up of what the true issues are. Yeah. I don't know. It's only just been recently introduced. I haven't seen it kind of permeate itself through the court process yet.
I mean, they have started letting legal bloggers into court, aren't they, and journalists. But I think that those cases are cherry picked, and they're not going to let them go into hearings where it's complex, and I mean mega complex, like when we hear things, you know, and they're not going to let them report. And I'm damn sure they're not going to speak to victims like they do if a journalist is sat in that courtroom, because it ain't going to happen, is it?
No, it's
And
almost like their own PR, isn't it? This is how the
yeah,
UK court system works. Look how kind we are.
yeah, yeah. I just think that judges need to be trained. They're not trained. They're not trained to recognise it. I think that they need to be opened
Well,
up.
I mean, the system is broken, and the judges, are flat out, case after case. And they are there to hear cases according to the law. Um, and but there needs to be some kind of bolt-on system, even if it's like an interim hearing that allows a professional like yourself or Dash or a person to come in and actually assess the level of domestic abuse for the court almost, rather than just through.
I've heard of judges saying to victims, just because you've got an IDVA doesn't mean to say that you're a victim of domestic abuse. And I just think that I personally don't think that it's a broken system. I don't think it's ever been right. I think many moons ago, it seemed to go in the mother's favour, where the child would automatically reside with the mother. And then I think the old Father's Rights Brigade kicked in, and that swinged everything round there. That swung it all around, didn't it then? Mothers constantly being accused of parental alienation and things like that. And, and I think, male or female, we can all be victims, and I'm not saying... I just think there don't seem to be any sort of balance in any of it. No, it's a lot of time it don't make any sense as to why, these decisions are being ordered. I think that they're not looking at the facts properly. I think that social workers are making assessments, and CAFCASS are making assessments on families that they don't spend any time with, so they've not got to know, that situation. They've not
And
got to know
favouring.
them, yeah, and not they've not got to know that family, when they can. We had a social worker said to a woman that we support that she didn't know which school a child went to, and I'm like, really? And you were preparing a report for court? And I just think it's bizarre, isn't it, that they can make these judgments when they're not getting facts right.
It's extremely concerning because, as we know, the court puts a lot of emphasis on what CAFCASS says, because it's like CAFCASS are doing their job for them, or they're relying on CAFCASS as the professional body to present the facts correctly. But yeah, you're absolutely right. And also, I think a lot of them are easily influenced by the charm of some of the individuals, and so that their reports aren't neutral. And you're right, some of the facts, we all know today I might be a really happy person, tomorrow I might be a really sad person, because they're just taking a snapshot of time when they do their reports that's supposed to reflect maybe years of abuse, and that doesn't always get the story and the facts together in the way that it should be done.
We support women that's actually traumatised by social workers and CAFCASS even more so than the perpetrator.
Well, this is one
Unbelievable.
of the reasons one of my clients has had to go to a 37, and as much as I've not liked to sort of point the finger at her, she's been so traumatized that she just didn't want CAFCASS or the police into her home because it was her only safe space. And bearing in mind, this particular person has post-separation abuse and is being abused by third parties and going through multiple court hearings. So as a result of obviously her not letting them into the home, I mean, they have seen the daughter, but they haven't been into the home. So really, just based on that fact, it went to a 37.
Yeah, it's just not. The entire thing is just a mess. They need a complete overhaul at system, I think, from start to finish. None of it's joint up whatsoever. You know, we've got.
But that's a radical change, isn't it?
Yeah, and I hear professionals like police and social workers and things like that, they are not trained in domestic abuse. They do not know how coercive control works. You know, and it can be spotted a mile off. And I just think that like I said, it just needs a complete overhaul. None of it's right. None of it makes any sense. It doesn't add up. It's not joint up. And you've got decisions being made on a lot of what's the word? Incorrect, fabricated reports and assessments.
And the thing is, this should all be part of the overall system, because at the end of the day, like we've said, a lot of these people come out of it, you know, with post-traumatic stress, with anxiety, with mental health issues, leading on to potentially addictions, suicides.
Yeah.
And obviously
but more often, but you know what, Jean? More often than not, it's the system that actually makes 100%. You know, I think that victims would, if they'd got the right system and the right support in place, then it wouldn't go on where they're having to use substances and things like that as coping mechanisms. Because
this is what I'm kind of saying. It may be one way of creating the more awareness and funding is to, you know, tap into some of these mental health services who have a responsibility.
We have a mental health team that actually referring to Resolute. They're referring to us because they don't know how. They don't know how to deal with trauma. It's too complex for them. And I suffered alcoholism and I became alcohol dependent because I used alcohol as a coping mechanism through my abuse. And it's like I've always said, my caseworker that I got when I came out of hospital, he had got lived experience and I connected with him. I told him everything. It was brilliant because I think when you speak to somebody that knows exactly what you're talking about because they've experienced it, I think you're a lot more at ease, because majority of people would look at you as if you are crazy and you already feel like you're going crazy because they won't believe that this happens.
I agree. Yeah. Are you feeling it on your own?
Yeah, and I can almost see how cases are going to plan out, particularly in family court. If they start showing too much emotion, they've got mental health problems. If they don't show enough emotion, then they're emotionally detached, and you know, it's like a double-edged sword. They can't do right for doing wrong, and it's literally like rolling a dice when they're going into that room.
You've got victims going through court that are in a fight or flight space.
Yeah.
That's not a place to be in court to be making decisions about yourself, your children, or anything else.
No. And I just think that the lack of support needs to be. There needs to be more awareness raised about it, because it's not good enough what's happening at all. But I think people are saying change is coming, but it's not coming fast enough, and we're certainly not seeing any changes coming at all. It seems to be that it's gone from bad to worse, if anything. And a lot of it is, you know, simple procedures that could be put in place that they won't put in place for whatever reason. And the Domestic Abuse Act may as well not even exist because professionals aren't adhering to them.
Well, I
to
just
it.
had a thought there about the professionals. I mean, you know, the solicitors and the barristers, we all know they're normally in the high income or their companies or their partnerships or whatever they work within are. Um, and really, they, in my opinion, they ought to have a corporate social responsibility fund,
Yeah, yeah.
almost like a mini legal aid or something,
Mm,
that either offers emotional, psychological, medical support, or legal support, because half the battle is you're up against, like I've said, perpetrators that are there with barristers that will just wipe the floor
yeah.
unless you kind of have some support.
And you have got to be one tough cookie, haven't you, to be able to stand in that courtroom and take that on top of what
Uh,
you've
yeah.
experienced. Some of them, they just rip them to bits. Absolutely rip them to
Oh,
bits.
eat them alive.
It's
Yeah.
heart wrenching. It's absolutely heart wrenching, isn't it?
I mean, I had a client in court last week. It wasn't, well, there was domestic abuse there, but that's not the issue. She was deaf, and even the facilities for people with, hearing loss or other disabilities is not accommodated either.
No.
In order for them to be able to be heard and articulate their position. Because with her, whilst they did try to facilitate it, at the same time there was a lot of looking at forms and then looking up. But by looking down, she wasn't lip reading, so she was losing. So she wasn't
Yeah.
able, and then obviously the processing takes a bit longer,
Yeah.
as it does with people with trauma.
Yeah.
Um, and so yeah, none of those fundamental, well, human right, if you like. So
Yeah.
so domestic abuse should be a human right thing rather
It
than
well,
a.
it's supposed to be. It's that human rights go out a window, don't it? At the end of the day, that they don't adhere to anything. It's like the laws. If the police aren't enforcing them, what's the point in having them there? What is the point? And then it rolls on. It rolls on to that, doesn't it? Because if police hadn't done their jobs right, then you've got social workers that are getting their jobs and assessments not right because they're not getting the time to spend with that family to do proper assessments and reports. And then by the time you've got to family court, what are you faced
Oh,
with?
I mean, I've got one client at the moment, and I'm supporting her, but I really don't know what more I can do. She's approached police. She's approached Solace, a support agency. She's got a non-mole. She's been to court. She's fighting back at the school and the local council from third-party complaints. Um, there's nothing more that she can do
No.
to
And do you
say
know that? Do you
hello.
know that this government apparently takes domestic abuse as seriously as terrorism? I've actually got that on paper from the Home Office. Can you believe that? Yeah. It's shocking. It's shocking. It's not taken seriously at all.
No.
Um,
Well,
and
hopefully you've enjoyed some of my insights.
yes, it's been lovely. It's been really lovely talking to you, Jean, and trying to get to know what it's. I think it's only a snippet of what you actually do, because I get it that it's hard work emotionally, isn't it, to do what you're doing.
It
Um,
is. It is. But I like hopefully making a difference to people's lives. There
yeah,
is so much more that should and could be done. I do what I can with the resources I've got,
yeah,
um, and yeah, live
yeah.
to fight
We've just
another
got
day.
exactly. Just got to keep doing what we're doing. When I set Resolute up, I said if I could help one woman, not go through what I went through on their own, then that's it. And
Well, that's kind of what brought me into all this work, not necessarily the domestic abuse. Well, yeah, But it was a case of, when I got divorced many years ago, the 20 years ago more, the facilities, even the lack of facilities that are available now were not available back then, and I literally had to, pull up my big girl knickers and get through it, and so. With my involvement, it was always about the divorce, but I kept on going off in different directions, and then it's all sort of culminated back in to this area now, is to try and help people, stop people, like you just said, from going through the pain that you experienced, and make life easier and get on with life quicker and sooner, if possible.
Yeah, so we'll end it there then. And we're running out of time, but we will definitely have another chat.
Lovely speaking with you. Good luck.
Yeah, you as well. It's been lovely to meet you, and thank you so much, Jean, for agreeing to do this.
No worries.
Thank you.
Cheerio.
Take
Bye-bye.
care. Bye.
Bye.